Hello friends, Namaskar. You are welcome to our show Dr. G.K. Goswami IPS. Before we begin, there is one request that you are giving a lot of love and affection to this channel, but I sincerely request you that please circulate this content, this YouTube channel among your friends, among your groups, and also subscribe. Your subscription will certainly provide us wider circulation, and this information which is being provided on behalf of the UPSIFS Lucknow by me, the founding director of the institute, will circulate among various people, various groups, students, faculties, academia, professionals and all. So let us begin our show Dr. G.K. Goswami IPS. So today we are going to start one very seminal topic, determination of age. Dear friends, this topic is very important. Why? Because age determination is important in various legal nuances, like in POSCO cases, where the age of a person, whether it is below 18 or not, it is contested, because the law under POSCO is very, very stringent. Likewise, the person, the juvenile, which is in confrontation with law, sometime it is contested that the person is above 18 years. So whether the person in conflict with law is juvenile or not is also contested. Likewise, the child custody, maintenance, sometime how to determine the ward or the Guardian Act. So there are various dimensions whereby the age of a person is very, very important. So let's see how important it is. So we will start some introductory part. If we look at historical perspective, so friends, the age of majority was initially 21 years. Whether you go to Roman culture or the English common law, the majority age was 20 years. But after post-World War, when the civilization grew further, the education spread, the mental ability was expanded for the common man, so the age was shifted from 21 to 18. And 18 is still prevalent among most of the jurisdictions. So 18 is the age whereby the person becomes adult. So 18 is the cut point. And 18 has so many rights involved. The moment a person becomes major, he has the voting right. He has different connotation for getting citizenship. Likewise, for education and various other domain, employment and so forth and so forth. In Indian scenario, if we look, the Indian Majority Act 1875 deal with section 3. So section 3 of Indian Majority Act 1875 says, quote, every minor of whose person or property a guardian had been appointed by any court of justice before the minor has attained the age of 18 shall be deemed to have attained majority when he complete his age of 21. So there are two factors here. If you see section 3, 18 year and 21 years. So what was the summary before 1999 when the amendment was made? General population, when there was no guardian, the age was 18. But when there was a guardian appointed, then a person when becomes age of 21, only he becomes major. So 18 was those who have their parents or the defined guardian. That age was 18. But for those persons who have appointed a guardian, for them the majority age was 21. Likewise, for marriage, the age for male was 21 and for female 18. Although now after 18 male and female, they get married without any legal restrictions. As I mentioned, to appoint guardian, the law of the land in India is the Guardian and Wards Act 1819. And that says that court appointed guardian, as I mentioned earlier, in consonance with Indian Majority Act 1875. So there is a equilibrium between the Majority Age Act and the Guardian and Ward Act of 1890. So court appointed guardian, the person will become major when he attain 21-year age. For the orphan children with absent parentage, property management for minors, close nexus between Guardian Act 1890 and the Majority Act. So let me summarize up to this part, that in India, since beginning from the Majority Act 1875, age was 18 for common people and age for majority was 21 to those the guardian were appointed by the court. Now there was an amendment in the Indian Majority Act 1875. That amendment was brought in 1999 and it was effected from 16th December 1999. Here section 3, the age of majority of person domiciled in India, every person domiciled in India shall attain the age of majority on his completing age of 18 years and not before. So now friends, the age 18 is final irrespective of whether a person has guardian or parents or the appointed guardian by the court. How the method or how you determine the age when there is a conflict in the court of law or for any other reason. So these are three methods, friends. One is document based. Normally document generally the birth certificate, but birth certificate are not being accepted in court of law under various sections. We will discuss it later. But birth certificate is also very, very prominent because birth certificate is being asked even at the time of admission in the schools at early stage or in municipal corporation also. So birth certificate is baseline to determine the age of the person. But for various reasons, many persons, especially the early time, the birth were being carried out, the delivery were being made at home. So there was no medical aid required or not available sometime. So the birth certificate from hospital were not available. So generally what they do, they generally get the birth registered in the birth register of the village or in the municipal corporation. So that birth certificate become important. The second document is school records. This is very, very important. A school record has two very important factors. One is matriculation certificate, and matriculation certificate, my dear friends, is very baseline to determine your age. Even if you have done all kind of education, the highest one, maybe you are PhD, but still your high school, your matriculation certificate is very important for mentioning or to verifying your date of birth. The another one is national identity, like your UADI card, that is called Aadhaar card. Aadhaar card is also having your date of birth. But again, Aadhaar card date of birth is based on your educational qualification, particularly your high school education if you are high school qualified. Otherwise, some other documents they generally demand when you are going to get issued Aadhaar card in UDAI office. The second method for age determination is physical examination, and this method is very, very subjective. It is influenced by external factors like your nutrition value, your health issues, your genetic character. Some persons are very tall, parents are tall, so the children may be tall. Likewise, the geography, say in various part of country, somewhere the general population has short stature, somewhere it is middle sized, somewhere it is very, long height, or the height is very long, like maybe 6 feet plus and so. So there are various reasons. So physical examination has no uniformity. So practically speaking, for our purpose in legal domain, the physical appearance merely has no legal sanctity to determine age. But sometimes it is important, say you have a child of very young age, so there is no conflict whether the child is minor or not. But when it is age of 16, 15, sometimes 14, maybe 19, then physical appearance is very blurred, or there is maybe conundrum in that. The third is medico-legal examination and scientific tests. Here the accuracy is plus minus 2 years. This is very critical and important to understand. In any medical examination, the accuracy rate or the error rate is plus minus 2 years, which is very critical. We will discuss this sometime ahead when we will move further. And these medical examinations are broadly of various types, but dental examination, molar, teeth, and so many other examinations we will discuss little more in the other slides further. Then another one method of medical examination is ossification test, where your skeletal maturity is being determined, and that help you to determine the age, and where you will see the wrist, your elbow, your shoulder, your clavicle, and their calcification and various other factors help to determine age of the person. Now the another which I mentioned already, the dental examination and dental x-ray. Earlier it was the other, like where this I mentioned about dental examination. This here it is little more dental x-ray, and this method is called Demirjian method, and sometimes it is called orthopentomogram. Orthopentomogram, OPG. However, here again there are a lot of variation. There may be ethnic variation, there may be regional variation, there may be calcium deficiency in the human being, or various others. So this is also not error-free. Further, radiological examination, the skeletal X-ray. Generally, we prefer to take X-rays of long bones, joints, clavicle, pelvis, iliac crest, knee joints, and another important method is CT scan, which is more intrusive but give more detail, the vibrant details. Then the forensic odontology, although we can merge this forensic odontology with for the dental examination, but here the forensic odontology go for little more detail, like cementum annulations, tooth pulp ratio, and other little metadata analysis the forensic odontology does. The seventh method is biochemical method and genetic and molecular method, but in conclusion I can say that none of these methods are perfect. None of them are able to give you the exact or correct date. But in legal domain, we need correct date, because say, for example, somebody may be 17 years but may not attend 18. So till the person is 17 years and 364 and say 23 hours or like that, still the person is minor. But the moment the clock touch 12 in the night, the person become or transform into an adult, the moment he or she get age of 18. So that is the crux. Now, as I usually do, I have already comparative chart for this. That's very simple, and this is my hobby, to make a comparative account. So I have given various methods, range, age, where it will be more useful, then means accuracy or the chances of error, and few remarks. So let's see first the clinical examination, the physical appearance and other things which is important, and that may be given at the age of 10 to 18 years, but accuracy is very low comparatively, and it is influenced by nutrition, hormones, ethnicity, geological areas and many more. So not very much reliable. Then dental eruption, demiregion, like molar emerge at a certain point of time and all. So 15 to 17 years is the range of age. It is accuracy is moderate and it is little bit standardized, globally used, but only for children. You cannot use it for adult. Adult in the sense, suppose somebody want to know whether I am 24 or 25 or 30 or 35, this method is not going to help you. Then skeletal X-ray, 0 to 18, it is again little bit to higher side, but not very foolproof. Error-free, nothing. Clavicle ossification is, the accuracy is high and it is used up to 18 to 25 and slightly more reliable. MRI CT scan is high resolution methods of scanning, and here you get high degree of accuracy, but again not perfect. However, it is non-invasive and with high resolution. So in summary, I can say that these methods are quite useful, but they are not error-free. So the margin is plus minus 2, so you get stuck in those cases where range is 16 to 20. That means in minus side from 16 and for plus side up to 20. So this 4-year range is very critical, and this is important whether it is rape case. So generally when the girl are little above the adolescent age, they may be 16, 17, at that time the defense generally argue that look, the prosecutrix or the victim of the so-called crime is a major, and if even DNA prove the sexual act, they say that being adult it was consensual. So I have no, I did no wrong, or I am not a culprit. It was consensual sex. So this is the crux, and I hope that you could understood the nuances of age determination. How important is the age and how difficult it is to deliver justice or to adjudicate in such matters. Now let's see the classification of age. Very important. This is a very significant to understand how to classify age. The first classification normally used for legal purpose and common sense also, the chronological age, the date of birth. Suppose a person born or such and such date, that is called chronology, chronological age. And most of the time or almost every time we determine age based on chronology, the calendar date. It denotes number of years the subject has lived. In stricto sensu, recognize only chronological age being irreversible. This cannot be. There cannot be doubt if the date is correctly mentioned. It is resistant to external factor. It will not be. Suppose a person is born in South Africa, in India, in Pakistan, any part of the world, even on the universe, any part. So the chronology will not change. Then another is biological age. Biological age means physiological aging. It refers to how old a person appears. Biology of a person is conditioned upon his physiology and so his age. So biological age by appearance, by how he looks, and for look there are a lot of internal physiological, hormonal and various other things which are responsible. So biological age is also not going to help you much in the legal perspective. The third and foremost is the mental age. Mental age means that the intellectual ability of a person. In common sense, we determine intellectuality in the form of IQ, intellectual quotient. This mental age is very important, my dear friends, in such cases that the person may be chronologically, by chronological age, may be adult. But because of mental age, his actions or her actions may be like a minor. This very issue was raised in very important case, and I suggest you, my dear friends, those who have legal concern or maybe in legal practice by being a judge or by being a prosecutor, a student in academia, this judgment is very important and even for a sensitive person. ERA through Dr. Manjula Kippendorf versus State of NCT Delhi. This was decided finally by Honorable Supreme Court, and precisely the bench was headed by Honorable Justice Deepak Misra ji. I had occasion to discuss this case with Honorable Justice Misra, Deepak Misra sir, on this point. This case briefly was that Miss ERA was chronological major in age, but her mental age was about 7 to 8 years because she was mentally challenged and she was sexually exploited for very long time. This matter was brought to Dr. Manjula, and she was very sensitive lady, and she brought a PIL in Supreme Court under Article 32. If you remember writ, recently we have discussed. So in that writ, the matter was brought before the Honorable Court. In this case, it was requested before the Honorable Court that to provide the advantage of the victim of sexual offense where the victim is minor to the extent because their intellectual capacity is very low. So the request was that even if chronology age may be major, you may be born before 18 years, but if you are sexually exploited or if you have some breach of right and you are mentally challenged and your IQ is below 18. My dear friends, normally a mentally challenged or retarded person has IQ ranging from 3 to 8 or 9. So like age, the child has from 3 to 8 or 9. So this girl was having the mental age of around 7 to 8. So petition demanded that she should be treated like a child, like minor, because mental age is 7 to 8, by which if this request or this plea was accepted, then she could have treated under POSCO Act, which provides lot of protection to the minors against sexual abuse. However, the court declined the request by saying that definition of child cannot be changed by the Supreme Court, and it is the prerogative of the legislature. It is the prerogative of Parliament to consider such vital issues, and that's why the demand was declined and petition was dismissed. But the seminal questions remain whether we should leave these type of sensitive issue like that only. Are we there to have the advanced version of our legal interpretation? I think we should consider it as a special case. That's my humble request. Now, why we need age determination? Although by now you must have understood, but I will categorize and I will crystallize the argument why age determination is critical, why it is very important. It is important for POSCO cases because victim may be a minor or major. This may be contested, so you have to prove the age beyond reasonable doubt. Then a person may be conflict with law, and if the person is juvenile, then he or she will get advantage under the act called Juvenile Justice Act. Earlier it was of 2000 but was repealed, and now it is JJ Act 2015. Then age determination may be required for child custody, for guardianship, for maintenance, for inheritance, and many more such legal contests. However, as we discussed to greater extent, but we will again look what are the challenge, what are the legal problems in determination of age. So one is absence and credibility of documents. Sometimes a person may be very ignorant or illiterate, may not have any means, so he or she may not have any document to prove her or his age. So absence of document is problem, and country like where a majority of people are suffering with marginalized circumstances in the society. So they may not have the formal documentation, proper documentation which can be admitted in court of law. So this is one. The another one, the document's credibility. Many times the document you may have, but whether their credibility is established, that's another point. We will talk on that little more about the credibility of the birth related documents. Then the reliability and digitalization of medical method. We have discussed the error rate is plus minus 2 years. So very, very critical problem. Then human right concern. Various methods, they are invasive in nature. They challenge your privacy rights. They expose to radiations when you are conducting X-rays or your other scans, CT and others, MRI and all. Then ambiguity in legal standards, various jurisdictions. Even the court, I will show few cases how the legal interpretation may vary from judge to judge, from court to court. So this is, there is no uniformity in interpretation, there is no uniformity sometimes in the laws itself. Then there are so many procedural delays. Suppose a girl is of 17 years and subjected to sexual harassment, POSCO case was registered, but unfortunately the date determination was not done timely and she becomes 19, 20. So very difficult to say that before 2 years what was the situation. So procedural delay also create more trouble to determine age. Now let's see what are the provisions in POSCO, because POSCO is very important. I have done extensive research on POSCO, especially the legal implications, and my second PhD, which I concluded from Tata Institute of Social Science in 2018, deals with almost 4,200 odd cases of Supreme Court and High Court on POSCO up to I think 15 June 2020. So with that extensive study, I, being a police officer and a prudent citizen of the country, I am very much sensitized with these things, and I want to sensitize you as well that probably the sexual offense with child is the worst thing possible for any society. And you will surprise that there is no age for sexual harassment, sexual abuse, right from almost 0 age to any upper age. So there are instances. Now we can see that how brutal, how inhumane the society is for any person. Anybody may be victim. So in POSCO, if we see, section 34 is very critical and important for age determination. What is that? Section 34 says procedure in case of commission of offense by child. So it deals two things. One, the person who is in conflict with law, whether he or she is a child or not, the age will be determined by section 34. On the other side, determination of age by special court, whether it is a child, the victim is child or not. Section 34(1), the subsection of 34, age determination for child who committed crime under this act. Sometime the situation may be the victim may be minor, even the accused also says that he or she is minor. Very interestingly, the POSCO is asexual. That means it equally treats male and female, because sexual assault, whether it is penetrative or non-penetrative or any other sexual crime with child may be with the child, and the accused may also be a child. So both may claim to be a child. That is why section 34 deal with the victim as well as the person or the child in confrontation with the law. Section 34 subsection 2 says age determination whether a person is child or not. However, if we see other than 6 section, there is no provision. That means that there is no laid down principle how to determine age. 34 only say that this special court will determine age. That means the final authority to determine age would be a special court, a special POSCO court. But how to determine? What are the methods? The POSCO Act is silent. This problem was raised in Jarnail Singh case. Jarnail Singh versus State of Haryana in 2013. Remember, POSCO Act was implemented from 14th November 2012. 14th November is Children's Day, the birthday of our first Prime Minister, Pandit Jawaharlal Nehru, 14th November. So, just after that, about 1 year, this matter came. And in this Jarnail Singh case, Honorable Supreme Court find that there is no procedure laid down in the POSCO. So, Jarnail Singh case, the Supreme Court says that until and unless POSCO is being amended and procedure are being specified by our parliament, till then we have to use Rule 12 of JJ Act 2000. Mind it, the JJ Act has been repealed and new JJ Act is placed in 2015. Now JJ Act 2015 is in operation, but that time it was 2000. So under JJ Act 2000 the rules were framed, and those are called JJ Rules 2007. Rule 12 of JJ Rule 2007 has given various methods. We will talk in the next slide. However, if you are interested to see more detailed discussion in various judgments, these are various judgments I have mentioned, right from Mahadev versus State of Maharashtra, State of Madhya Pradesh versus Anup in 2015, and various latest judgment I have mentioned up to 2019. So for those who are from legal background, maybe honorable judges, the legal practitioners, the academia in legal field, or NGOs and many more, they can take help. Now we have to examine the JJ Act 2000, especially JJ Rule 2007, Rule 12. But after repealing JJ Act 2000, we have introduced the new JJ Act 2015, which was operational in 2016. In JJ Act 2015, Section 94 has given detailed procedure for age determination. So earlier it was Rule 12 and now it is Section 94, under which the age determination has been mentioned, how to do it, the method, the procedure. So this is the comparative. Again, the comparative business is there. Always it is my, you can say, hobby. So procedure for determination of age, a comparative matrix. So left side I have given Rule 12. This side I have mentioned JJ Act 12. JJ Act 2015 hai. This is mentioned wrong. So Rule 12, procedure 12 subsection 1, used for child or juvenile in conflict with law. Here section 94 says it is presumption and determination of age. So it is presumption as well as determination. Here it is procedure for age determination. Here it says that in case the committee on board has reasonable ground for doubt regarding age, shall take following procedure of age determination by seeking evidence by obtaining. इसके बाद afterwards we will tell you the procedures. This side, section 2, it says the court or board of committee decide age based on physical appearance or document. So here physical appearance as well as documents is given. However, rule 12, sub rule 3 give the detailed procedure. So now this is the most important slide for our purpose. This gives you the entire gambit. So these are the methods I will explain, and how these things have been slightly modified in section 94 of JJ Act 2015. So now rule 12 does not exist. Now you have to deal with section 94. But I am giving you a comparative chart because as a lawyer, as a judge, as a prosecutor, as a defense lawyer, you may be dealing the old cases also before 15. So there rule 12 may equally be important. So first, if you are determining age of a person, you first have to see the matriculation or equivalent certificate. That means high school, 10th level. If it is not available, in absence of that, it may be because a person may be minor, may not have age of completing 10th class, maybe he has not done it, he may be illiterate, he may be class 7th pass, so not necessarily that everyone has matriculation certificate. So if it is not available, then only you will go to the second. What is that? The date of birth certified from school other than a play school. First attended. It is not that in earlier you have written some different age, but later you have written or modified it and then you produce. So the first school which you attended. In absence of that, there may be some persons who may not attended any school or may not be having the certificate for various reasons. The school might be closed or so many other reasons. So if it is not available, so in absence of, it is clearly written, then you go for birth certificate given by corporation or municipal panchayat or village panchayat. When all these three are not available, then only you go for medical test. So my dear friends, this is the law of the land, that you should not jump directly to medical examination. You have to see first under rule 12, I repeat, matriculation certificate. If not available, then go for school certificate, the first attended school certificate, not the play school. Third, if it is not available, then only you go for municipal corporation certificate of birth or school or village panchayat, like that. If these three are not there, then only you go for medical examination test. However, the age determined by the authorities shall be conclusive. So you cannot challenge it. That is conclusive. Now let us see what are the changes in your 94. That is currently in practice or operational. So here if you see the date of birth certificate from school or matriculation or equivalent from concerned board. So these two, 1 and 2, have been merged into 1. So our section 92, subsection 2 and its part 1 have merged these two, and now whether it is high school certificate or the school certificate, both are merged together. So both have equal status. If they are not available, then only you go for birth certificate given by municipal corporation, gram panchayat or such type of organizations or authorities. If these 1 and 2 are not available, then only you go for medical test. That means, my dear friends, medical test is the last resort. You should not jump. I tell you, I will not give you the name of the organization or the particular case. A very sensitive case about 7-8 years back. I was in a very important organization as senior officer, and it was a very sensational case where a politician was involved, and later, for various reasons, his medical test was conducted despite at that stage the charge sheet was filed and everything was being done. So later, when the trial was commenced, then the stricture was passed against investigating officer, that when there was no confusion on this, why have you conducted medical test? So my suggestion to you, my dear friend, is that if you are IO or anyone, please avoid to jump medical test immediately before exhausting the other provisions of the law. So that is very, very important. Read that very carefully. Recently, I was delivering a lecture. Even a research scholar was confused in this. So be very cautious and careful that how the age determination principles under section 94 should be implemented. Now, the legal necessity. The legal necessity in age determination, there are certain regions, certain facts which has to be proved and very important. You cannot conclude age determination merely by looking at section 94 of JJ Act 2015 without understanding the nuances of section 35 of the Indian Evidence Act. And what Indian Evidence Act says, it says that the document must be nature of public or the official document. It must be state of, it explain the state of facts, and the entry must be made by a public servant. Now, what happens? Why section 35 is important? We should understand that suppose you go to school and you say that the child has been born on such and such date. So on what basis you are claiming, whether you have any medical certificate of birth or any other reason. So until unless you have some justification of the entry made into that document is important. So you go to school, get your child registered for some class and submit some document. So what are those documents based on which the school entry has been made? So those documents are important. Now you see the scenario which are very, very critical. Suppose there is a child who is suffering or who has suffered the sexual offense, maybe the girl may be 16 years or 17 years, and from a marginalized family. The father does not know what the school is. The child is also illiterate or maybe literate, but at the time when the birth was taken place, then the documents, the child may not be aware at all what has been done. And when the section 35 is verified, the advocates ask various questions. Suppose date of birth is written 6th June 2012. Now the question will be asked that what is June? What is the month before June? How do you say it was 6th June? So the poor father will not be knowing how to answer. So this section 35 sometime, despite the genuine documents, creates confusion. So we have to be very sensitive, and I want that you, as whether you are a judge or any role you have as an actor in criminal justice system, you should be very sensitive on such issues. If you want to learn more on this application of section 35 of Indian Evidence Act, you can see this very important judgment of 2009, Sikkim versus Girjaman Rai, alias Kami. This is a very important case. Now, age determination by document. What are the inherent challenges in these documents? One thing I have already told, that despite the document may be genuine, it may be from the school has all records and there is no confusion in that, but you have to fulfill the ingredients of section 35 of Indian Evidence Act. Other than that, the proof of age, school leaving certificate, transfer certificate, on its own is not sufficient for proving date unless examined the official in charge. In this judgment, C.D. Reddy, the Honorable Supreme Court said in 2020 that merely by submission of that you are a matriculation certificate you have to call the school authority who has mentioned the date of birth, and again section 35 will operate. So this is a ground reality how the age determination has criticalities. Then credibility of information. I have already told you that credibility of information of birth is very important. Here again section 35 operate. Sikkim versus Girjaman Rai. I have already given you this judgment essence in the previous slide. Then determination of parentage. You know the section 112 of Indian Evidence Act 1872 and now section 116 of Bharatiya Saksh Adhiniyam 2023 deals with the presumption of parentage, the paternity, or the conclusive presumption of fatherhood. So the documents which has mention of father, generally nowadays even name of mother is also being entered, but earlier only father. So I can say the parents, you can take the word. So parent mentioned in those documents also have validity in documents, and that can be seen by in this judgment Muhammad Salim versus Samsuddin in 2009 by Honorable Supreme Court. There are certain judicial observations, and I want your attention because this case, to my understanding, is highly sensitive case. Although Om Prakash versus Union of India has been recently decided by Honorable Supreme Court, a very touchy case. Why? Because the claim of juvenility, the accused at that time was of 14 years, Om Prakash. Although he was a dreaded criminal, dreaded act was criminal, I can say. I should not say dreaded criminal, but his act was heinous. What he did at that age, he killed 3 family members, including Colonel Shyamlal Khanna, his sister and his son, who just came back from abroad after completing his study. They were sleeping in the house, and Colonel Khanna, after taking tea, he went out for a walk and came back, and then Om Prakash killed all 3 persons, and wife, by sheer fear of the act happening in the house, locked herself in the toilet. When there was a lot of hue and cry, this man tried, and again she was also brutally injured. Somehow she was saved. So this boy at that age was absconding, flew away, and he was being arrested only after 5 years, when the message or the news was circulated on Most Wanted means TV channel program. Cutting story short, when he was arrested, his statement was recorded. He disclosed, it was claimed by the police, that his age was 20 years at the time of crime was committed, and he was treated as adult. Later, in appeal at High Court, he gave the plea of juvenility, that he was at the time of crime, he was 14 years of age. When I deeply examine the documents of this court, history of the facts, it was mentioned that the age 20 was mentioned because Om Prakash opened a bank account in State Bank of India where the age was mentioned 20 years and passbook was issued along with checkbook. That was the base. When appeal was filed in High Court, then it was claimed that he was 14. But court said that you have not mentioned this fact during trial or investigation at all, so we will not take the new evidence, and it was thought that it is afterthought program. Cutting story short, this person was awarded death penalty up to Supreme Court. The matter went to mercy appeal before Honorable President of India. Then Mrs. President of India, Honorable President of India, remitted the death penalty to life imprisonment up to when he attained age of 60. That means up to the age of 60, he will be behind the bar and then only he can be released. In 2017, the mother of Om Prakash filed an appeal, again contested for juvenile right, that he was juvenile at that point of time. The High Court of Uttarakhand rejected the appeal, saying that it is concocted, it is planned, and no such method, not such subsequent afterthought plea can be entertained at that stage when the matter has achieved finality, because everything has been done. Supreme Court has already decided. The mercy petition has been decided. How can we open this case? Against that dismissal petition by the High Court, matter was appealed before Supreme Court, and this is the judgment of 2025. Honorable judges have taken a humanistic approach, saying that he was truly a minor, he was a juvenile. And when the fact was revealed, the bank says that we do not see the age of a person for opening the bank account. Even a minor can open the bank account. So see, even the High Court, the Supreme Court has presumed that a minor cannot open the bank account. But the fact was contrary to this assertion. That means that from earlier time, even a minor can open the bank account. He was, although found guilty, because he was guilty, that was not a doubt, but considering that he was a juvenile, he was immediately relieved from the jail, and lot of comments were being delivered by the Honorable Supreme Court in this judgment. So this is a sensitive case, and how age becomes important for any matter. This is again a very important matter, and I want to, with humble request, with my all, you can say, decency, and as a student of law, I humbly submitted and present this matter before you all to consider. This is a case very recently being delivered or being adjudicated by the bench of Allahabad High Court in my own state. The name of the judgment is Aman alias Vans versus State of Uttar Pradesh, 2024. At para 13, it was a case of POSCO basically, and this case has narrated, I think, more than dozens of cases where in the opinion of the Honorable High Court, the POSCO case or the POSCO Act has been misused. That means the victim has wrongly implicated the accused. So court felt very much annoyed with this approach of the victim, and the court has directed the Director General of Police of Uttar Pradesh as well as the Director General of Health Uttar Pradesh to follow the certain guidelines, and it made medical examination of victim to determine age compulsory. That means that irrespective of section 94 or earlier rule 12 of JJ Act 2000, that which says that only as the last resort you have to go for medical examination. But here the Honorable High Court has directed that you have to compulsorily go for medical examination. And it is not only in the judgment, it has been circulated or it has been issued certain guidelines to implement the fact or the ratio decidendi of the case. The court said that medical report determining victim age at very outset will also help prevent misuse of the POSCO. It also says that said medical report are relatable to specific provision of law. With due regard, I observe that if in every case the medical examination of the victim is made compulsory, that is not abiding the provisions or the parliamentary intent of section 94, which has categorically mentioned that which provision for age determination we used at what stage. Medical examination is the last stage. The court observed at para 17, false depiction of victim as a minor in POSCO Act cases is an abuse of the process of court. Then the court kept observing medical report determining the age of POSCO Act offence is an imperative requirement of law and an absolute necessity. This is with due regard, is not imperative of law, because law is slightly different, which we have already discussed. It issued direction to DG Police and DG Health of UP to mandatory conducted age determination by medical expert, and those who want to see at para 2023 these guidelines can be seen. You can also see one another important judgment relevant for this purpose, Anuruddh versus State of UP 2014-24. In Aman, interestingly, neither section 94 has been referred, nor rule 12 has been referred, nor General Singh has been referred. Only the case of High Court, Allahabad, are being referred. So, what I mean to say, that interpretation of law also varies sometime by the court also. And I believe that Aman alias Vans needs to be revisited from the lens of section 94. That's my humble observation and request. With this, thank you very much, my dear friends. You have patience to listen me very affectionately. Your comments, I always feel, are highly motivating to encourage us, and it also boosts the morale of our institute, and the UPSIFS is now open for admissions. So you can visit our site for admissions for forensic science, graduate postgraduate courses, for legal studies, for graduate postgraduate courses, for technology, for that means BTech, MTech integrated course, and MTech. So be with us, enjoy the time, and subscribe the channel. Thank you very much. Namaskar.